Greetings, everybody. Keith Stickley with the Stickley Law Firm here in downtown Hillsdale, Michigan. I'm a criminal defense attorney, and today we're going to be talking about the misdemeanor court process. In other words, what actually happens from start to finish when somebody is accused of a misdemeanor crime. We're going to talk about what is a misdemeanor, what happens when you're arrested, what happens in the trial process, how does bond work, all sorts of things that people who find themselves on the wrong side of the law have to deal with, and often they find very confusing. Now, something that I noticed after working with thousands of clients over the last few years is that many people who are accused of misdemeanor crimes have never had any contact with the criminal justice system before. And very often they'll hire an attorney or they'll get appointed a public defender if the case calls for it and they qualify. And they work and they answer some of the attorney's questions and such, and the attorney goes and represents them, oftentimes very, very well. But they're still nervous because the attorneys get so busy, they don't explain from start to finish very clearly often what the actual process is and what they might expect. So I wanted to take some time to sit down and explain in general terms. Obviously, each case is specific, and this isn't, formal legal advice, but I wanted to explain the basic outline of the misdemeanor process when somebody is charged with a misdemeanor crime. And so that's what we're going to do. It's going to be just like you came into my office and asked, hey, this might happen to me. I might be charged with a misdemeanor crime, and can you give me a general outline of what might happen? I find that clients who have some of this knowledge, have a little bit of background and understanding, they tend to ask better questions of their attorney, which in turn helps their attorney better represent their interests in court. Also, it takes a lot of stress off when clients know exactly what's going to happen in what timeline and what reasonable expectations might be when dealing with a charge and in dealing with their attorney. So let's have a seat and let's talk about what happens step by step when you're charged with a misdemeanor crime. So to begin with, let's talk about a couple of basics, starting from square one. What is a misdemeanor crime? Well, a misdemeanor crime is a criminal act, an alleged criminal act, if you're not yet convicted, obviously, that the grand penalty, the ultimate penalty, the maximum possible penalty that one could receive is 1 year or less in jail. They're generally less significant crimes than felony crimes, which open somebody up to the potential of prison. Now, some people don't even know what the difference between jail and prison is, so we'll talk about that real quick. Pretty much every county in Michigan has their own jail. It's a local jail. They're usually a facility like you see in the movies. They'll have different cells and such. And the jails are used for two different things. One, people who are being held there on bond prior to a trial in either the district or circuit court stay in jail if they can't make bond or if there is no bond. And two, people serve sentences in jail, local time, sometimes it's referred to as. And those actual jail sentences never last longer in the state of Michigan than a year. So keep that in mind when we're talking about misdemeanors. Some examples of misdemeanors might be that are really common that we see a lot are domestic violence, which if it's a simple domestic violence charge, it's normally known as a 93-day misdemeanor. In other words, the maximum a judge could sentence somebody to on a conviction would be 93 days. Driving while license suspended is a 93-day misdemeanor. There's a lot of misdemeanors that coincide with the traffic code. So if you have a traffic offense, and I'm not talking civil infractions that aren't technically crimes, but if you have a traffic offense like an OWI, a first offense, or second offense, both of those are misdemeanor. So it is a lower crime, and it's a crime where if you're sentenced to incarceration, if you got to spend time in a caged facility, it's going to be in a local county facility, as opposed to a felony. If you're convicted of a felony and you have to serve more than 12 months jail, you go to a state-run prison facility operated in Michigan by the Michigan Department of Corrections. So that's a really important distinction to keep in mind as we're going along and talking about this stuff. So let's talk about what happens and how we even get into the court system when we're going to be charged with a misdemeanor. Well, generally, there's some sort of an investigation of an alleged crime, and this can happen several different times with misdemeanors. So sometimes people enter the criminal justice system for a misdemeanor crime by being arrested by the police. Commonly, probably most commonly, is somebody being arrested for, say, drunk driving. And what happens there is if there's probable cause to believe that there's enough to charge with a crime, they get the handcuffs on, they go through all the tests, they do all that, and they're transported to the jail, and they're booked into the jail, and then they're charged with a crime. So that's one way that a case can get started, a misdemeanor case can get started. Another way that a misdemeanor case can get started is simply by a law enforcement officer writing a ticket, okay? And we see a lot of these as well. And a couple examples of those kind of infractions where we generally see a misdemeanor crime charged without an arrest is in things like DNR tickets and some traffic-related offenses. Most DNR tickets, DNR officers don't often actually to formally put somebody under arrest with handcuffs and all that. They usually write them a ticket, and they tell them that they have 10 days to make arrangements with the local district court in order to come in for an arraignment process. So let's say you get arrested on a misdemeanor charge. And just for the sake of argument today, let's use the example that you are arrested on a drunk driving charge, okay? You're being arrested for operating while intoxicated. What would happen? Well, assuming that you go through all the preliminary breath test, all that stuff that goes along with it, and I know we have some videos about that, you're taken to the jail. Sometimes there's some blood tests or a data master or whatever. You are then fingerprinted at the jail. They got to get your fingerprints. They're going to take a photo of you, okay? And then they're going to document a bunch of personal information. A lot of times they take medical information because even though you're being booked in the jail, in theory, they want to make sure that you're safe. Then you enter this phase of the process called the initial holding, basically is what we would refer to it as. And that is where you're sitting in the jail and you might be told that you can post what's called an interim bond or bail, or if you have to wait to your arraignment. Now, if you are told that you can post an interim bond, that basically means that you are going to give the sheriff's department money to hold. They'll end up going to the court, but give money to hold to guarantee that you're going to show up at court when you're supposed to. If an interim bond is not allowed on your case, you're going to sit in the jail for 48 to 72 hours to the time that you are arraigned, what's called arraigned. That's sort of like the first hearing, if you will, in a court on your charges. Now, let's talk about the bond and the bail process and exactly what that is, okay? And there's basically three kinds of bail here in Michigan. There's cash bail, there's surety bail, and then there's a PR bond, okay? Now, if you're told that you have to post a cash bond, that means just that. You physically have to bring that amount of cash to the court, usually facilitated by a sheriff's office, and you have to let them hold that money, okay, as a guarantee that you show up. And if your case is dismissed, you get all that money back, and as long as you show up and don't have any violations. Or if you end up with a conviction, a lot of counties will apply that money to any fines, fees, and costs that you have. There's another kind of bond. The next kind of bond is called a surety bond. And a surety bond is what you've probably heard of a bail bondsman or a bonds company. So a surety is a bond where somebody else, a bail bondsman, posts the amount of money for you to get released on bond. Now, it's kind of a weird concept for some people, so let's break it down really easy. The best way to think about it is you are renting somebody's money for a fee, okay? You pay somebody a little bit of money so that they will give the court system a lot of money to guarantee that you'll show up. That's how they make their money. You're paying them a fee. If you don't show up, okay, that's seen as violating the surety bond, all right? And the bondsman will have the right, because you'll sign a bunch of paperwork, they'll have the right to go and capture you, literally physically capture you with no warrant, no rights. They can go wherever they want because you sign all that away. They can literally go in and just grab you, and they're going to take you to the jail. And then they're going to get their bond money back that they've posted, and obviously they get to keep the money because it's non-refundable, the money that you pay them for this service. Sometimes you even owe them a little extra money if you run and they have to capture you. That'll be in the contract that you'll owe them whatever it costs to capture you and bring it back. So if you're on a surety bond, if you have a bonds person post your bond, you want to read that documentation very, very closely. You don't want to violate that because it can cost you a ton of money. And the third kind of bond is called a personal recognizance bond. This is the easiest bond to deal with, and sometimes for a lot of people, it's the most confusing. So a personal recognizance bond means that you sign a promissory note, basically, to the system that says, I'm going to sign here. I promise, without putting up any money, I promise to appear back for all my court hearings and abide by these conditions. And if you don't, then you could potentially owe the court or the system some money, or they're going to charge you a bond if you violate. So how that normally works is at a court hearing or something, the judge or the magistrate will say, I'm granting you a PR bond for $5,000. That doesn't mean that you post the $5,000. That means that you get out on a signature, all right? But if anything happens, the court can go back and they can get $5,000. You don't want to do that. Or they'll reset a bond at $5,000 if they let you out again. So if you get out on a PR bond, that's a good thing. You don't have to have any upfront cash, but you got to be careful. You got to abide by the conditions. So step one in the formal court process, step one, the first hearing, is a thing called the arraignment. Now, the arraignment is a formality where the judge or a magistrate will formally tell you what it is that you're being charged with. Okay, in other words, in our example that we were using today, operating while intoxicated. And they're also going to read you and explain a bunch of rights. And you probably are familiar with some of these rights, but a lot of times they want to make sure that you fully understand what's going on. Obviously, you're going to have the right to a jury trial with a misdemeanor. If it is in a district court with a misdemeanor here in Michigan, there'll be 6 jurors, not 12. You're going to have the right, in most cases, if there is a potential that you might go to jail, you'll have a right to an attorney. If you can't afford one, they might provide a public defender for you. Now, the public defender that they appoint for you is not necessarily provided free of charge at taxpayer cost. In most of the counties in Michigan, you actually have to reimburse the county for that public defender. And this is why, especially in a lot of the southwest Michigan counties, for misdemeanors, a lot of people retain an attorney because they're going to end up paying for one anyway. And it's important that you get an attorney that you feel comfortable with, that you can communicate with, that seems like they know what they're doing in these specific charges, and you move forward from there. So what ends up happening at the arraignment is this. In Michigan, there is almost always a public defender on standby during the arraignment hearing. And all that attorney is there to do is basically guarantee that the court system itself has not violated your rights in any way. And they might help you put together some sort of a bond argument if you're pleading not guilty at the arraignment, so that you can get released on bond. Your attorney should, especially in a misdemeanor case, should really try to be arguing for a PR bond so you don't have to put forth money. There also at the arraignment is an opportunity to enter a guilty plea if you want to, okay? If you want to. I don't always suggest this. A lot of times you need an attorney to really look at what's going on, what you're being accused of, especially in cases like OWI cases where there's potentially a lot of evidence, a lot of scientific evidence. But it is your right. It's your right to go at arraignment in front of the district court judge and say, I'm fully guilty of it. I'm guilty. And if you do that, they're going to ask some questions. They're going to get what's called a factual basis. And you're going to plead guilty. And then the judge will set it up for sentencing. And some days they'll sentence you right then and there. That's pretty rare, though. Most of the time you have to come back for sentencing. So that's if you plead guilty. But at the arraignment, you should probably be entering a not guilty plea, getting a full scope of the situation, discussing the matter with legal counsel. And after you plead not guilty, the bond conversation will come in. The purpose of bond is twofold. Number one, it is to ensure the safety of the community. So the bond argument that you might have a little help with putting together is going to consist of elements of why this person is not a threat to the community, right? So if you're being it's kind of hard if you're being accused of drunk driving because, well, driving cars while intoxicated obviously could present a risk to the community. But there might be some stipulating factors that say, or show somehow that you really aren't that big of a threat. Maybe you've never been accused of such thing before. Maybe you don't have a car anymore. excuse me, maybe you agree to testing or some sort of a tether, an electronic device that you blow in and shows that you're not consuming alcohol. The second part is of the bond. The second element of that bond argument has to do with showing up for court. So the first is protecting the community. The second is for showing up to court. You want to make an argument to delineate, look, I'm going to abide by conditions and show back up for my court hearings. And ways that you can help make those kind of arguments include, hey, look, I've got reliable transportation. I live in the county, so the court's not very far away. That kind of thing. No track record of not appearing at any other sort of court hearings that were held at any other time, and so on and so forth. So at that point, the judge or the magistrate will enter whatever plea you're talking about, most likely a not guilty. A bond will be set, and you either have a PR bond that you sign out and the jail releases you and you show up to court, or you have to call a bondsman and you pay the bondsman to post the big bond, and then you get out of jail, or you have to post a cash bond where you literally physically have to bring a bunch of money to the court. After the arraignment happens, the next court hearing that you're going to be participating in with your attorney is a thing called a pretrial proceeding or a pretrial hearing. Now, in the district court with some of these smaller cases, pretrials, it's not uncommon to have multiple pretrial hearings. And it all depends on sort of how the court operates locally, and many different counties operate different ways. Hopefully, you've retained a competent attorney who's having conversations with the prosecutor before your pretrial conference, your pretrial hearings, to see if you can work out a resolution before you get there. Because at a pretrial, you are able to enter some sort of a plea deal if there is one. And we'll talk about that in a little while. There also is a chance that various motions might be heard or filed in a pretrial hearing. In our case of an OWI case, a competent attorney, hopefully you have somebody working with you who knows what they're doing, will look at all the evidence. We're talking dash cams, police reports, the scientific tests, any roadside sobriety tests, any blood tests, any data master tests. There's a lot of evidence. And sometimes your attorney will need to file motions for either dismissal or to keep certain evidence out or whatever. Those kind of things also happen in pretrial proceedings. So pretrial hearings are just sort of a general label, if you will, to the various kind of hearings that your attorney is going to discuss with you and potentially work out with the prosecutor. If you're going to a trial also, a pretrial hearing might include some scheduling orders. Courts are busy places, and sometimes it takes a long time to get your case to trial if, for instance, you think that you're totally innocent and you want to take it to a trial. It's always a good idea to really have an upfront, honest, realistic conversation with your attorney about timelines and how long this process might take for various pretrials and various hearings. Yes, it is true that people in the United States have rights to speedy trials and timelines. But it's my experience that if positive headway is being made in your case, you might want to be a little bit more on the patient side, or at least discuss those issues and concerns with your attorney, rather than going straight to the wanting something fast. Because when you put a lot of pressure on an overworked prosecutor, it's very easy for them to just throw up their hands and say, no, I'm not going to hear from you. We'll just proceed to a trial. And a lot of cases can be worked out outside of a trial. And that doesn't necessarily mean entering a guilty plea. A lot of times, reasonable heads will prevail, and defense evidence can be presented to the prosecutor that shows that you are in fact not guilty. And sometimes the prosecutor will be accepting of that evidence, and they have to do a little due diligence on that part so that they agree. And these things are not overnight, especially in Michigan's rural communities, where there's a complete lack of attorneys. A lot of times there's a lack of prosecutor staff, and sometimes these things just take a little bit of time. Now, the good thing is to keep in mind with a lot of these misdemeanor cases that we're talking about, most people in our experience were able to get them out on some kind of a bond, so it's not like they're just sitting wasting away in jail. And a lot of times things come up in the pretrial process with my clients. I could tell you as myself that we'll be in this process, and one of my clients will find some interesting evidence that helps their case. And it's very helpful if everybody's being a bit flexible with the timeline so that I can get that information to the prosecutor and we can make that part of the overall negotiation or resolution, or really even an element that we have to go and litigate out in a trial. So that's basically what happens in the pretrial process. It can be multiple dates. It can occur on multiple dates. It'll usually occur for the first time several weeks after your arraignment, as long as you're not in custody. If you're in custody, they usually happen really a bit quicker. I don't like my clients just sitting in jail on misdemeanor cases waiting for something to happen. I think that that's a problem. So if they are incarcerated, then I try to push the envelope there, at least to the point where I can get them out of jail on some kind of bond so that we can realistically deal with the case. So after all the pretrial stuff is done, we're basically left with three options in the misdemeanor case process. And that is sort of the, I guess, the adjudication, if you will. Number one, you can have a trial. Number two, you enter a plea. Or number three, we get the dismissal. And that's the best case scenario right there. But let's talk about those. So let's assume that we don't have a resolution. The prosecutor has offered us a plea bargain to something less, but it just doesn't seem reasonable, and we want to proceed to a trial because we're just not getting anywhere. We think we're innocent, and it's just we can't accept what they're offering or accept any responsibility for a criminal act that we haven't done. So we go to a trial, and there's two kinds of trials. There is a bench trial, and there is a jury trial. Now, a bench trial is similar to what you see on daytime television, kind of, with a couple of caveats, right? Those people are actors. A lot of those scenarios are preset, and the judges are just strong personalities, right? And they are always making the decisions. And that's kind of what a bench trial is, to be honest. It's basically a trial where there is no jury. It is simply the defendant or the defendant's counsel and the prosecutor, and using all the proper rules of evidence and trial tactics and court rules, the prosecutor makes their argument to the judge that this person, the defendant, has committed the crime beyond a reasonable doubt. The standard is just the same as if you had a jury trial. The standard is beyond a reasonable doubt, did this person commit this crime? And the defense has all the same basically options as if a jury was sitting right there. You can object to lines of questioning. The prosecutor will put up witnesses. The defense will put up witnesses. The defense will cross-examine witnesses and vice versa. It'll go back. And in the end of this bench trial, the judge makes a decision of who wins, who loses. That's how it works. Or there's the traditional jury trial. And the jury trial of a misdemeanor case is it's pretty formal. It's not maybe quite as formal as the felony jury trials, but nonetheless, a pool of jurors, a bunch of people from the community, are brought into the court, and the attorneys do a process called voir dire. The judge helps, and voir dire is where basically we get information from the jurors. That's kind of information. I should make a video on that. It's kind of interesting. What information we're able to glean out of juries and how that selection process happens. But a jury is picked. It'll usually be 6 jurors, and there might be 1 or 2 alternates, which in case something happens to one of the jurors, you don't want to have to throw out the whole trial, so that person can stand in. And then the trial starts. Opening statements are given, evidence is presented, closing arguments eventually come about, and then the case is given to the jury. And 6 jurors go back into the jury room and they deliberate and they decide whether somebody's guilty or innocent. So that's the trial process there. The second possibility is that there's a plea. In other words, the defendant accepts responsibility for the crime. Now, they don't always plead straight up, which is they don't always plead exactly what the prosecutor has charged them with or given them. Sometimes the prosecutor will say, hey, look, plead to this lesser charge, and then we don't have to have a trial. So if that happens, the judge asks the defendant a bunch of questions to make sure the defendant understands what their rights are. that they're not being pressured into pleading, nobody's bribing them, they've had a complete thorough questioning and understanding and conversation with their attorney to know what's going on, and then the judge will ask for a factual basis. In many cases, I like to ask my client the questions for a factual basis because the client has to basically admit what happened on the record. A smart defense attorney will know what answers they need to get out of their client so that the plea is accepted, but at the same time not implicate them in any other sort of crime or problem that sometimes can occur during a plea. And that's how I like to operate, and I think that that's probably the best case scenario for most of my clients. But sometimes the judge will actually ask all the questions. And then the third option is the ultimate, and that is getting a dismissal. Sometimes on motion of the judge, to the judge, you can get a dismissal. And other times what can happen is basically the jury gives you a not guilty, or the prosecutor has the right to do a thing called a nolle. And a nolle is basically when the prosecutor says, you're right, we're not going to a trial, we're not having anything else, but we admit that there's probably not enough to go on here, so I'm going to sign this paper, and that is going to formally dismiss all the charges, and then the person just goes on with their life. Now, if somebody's actually convicted of a crime, they're going to go to the next phase, which is called sentencing. And there's a sentencing in the misdemeanor world can vary wildly from judge to judge, even on cases that are similar. And so various things can be jail time, fines and costs, potentially probation or community service. But what oftentimes happens after a conviction is that somebody will meet with the probation department. And the probation department will have them fill out some questionnaires to learn a little bit about their life, because sentences are supposed to be narrowly tailored in the state of Michigan to really address any needs as well as punishment for the particular person. So by answering these questions, the judge can get oftentimes a recommendation from the probation department of what the sentence should be. And it's important that you go over what that sentence should be with your attorney, so that you can maybe make any arguments of if you think the recommendation's too harsh, of why you should be sentenced somehow in a different way. Additionally, if you're convicted by a jury, a lot of times there is the capability for some sort of an appeal. And it's really important to ask your attorney after you get convicted, before sentencing, if there's any appeals options that should be explored, or any documents or evidence that should be basically consolidated and preserved for the purposes of an appeal. So that's basically it. It's a pretty simple process. It's not necessarily an easy process to go through, but those are the main steps in how Michigan deals with misdemeanor criminal cases. So there it is, folks. In a nutshell, that is the step-by-step process that the judicial system here in Michigan takes when dealing with misdemeanor cases. It's important to maybe check over this video a couple times. We've tried to break it up here by chapters so you can easily find information on the individual topics that actually happen, the individual steps that happen in a misdemeanor trial. And if you have any other questions or you're looking for quality legal representation, feel free to reach out to my office. We're here in downtown Hillsdale, Michigan. We serve all over the state, all types of misdemeanors, and we'll be glad to help you out if we're able to. Stay safe, and we'll talk to you real soon.